Welcome to the Grow Rich podcast by Tech Help Canada, where we share the best online marketing and general business tips. Now for today's host.
Note, this includes AI-generated narration. For years, the fight over social media harm mostly lived in hearings, parent complaints, internal research leaks, and public arguments about whether platforms were going too far. Now it's landed somewhere tech companies tend to take very seriously, a jury verdict. On March 25, 2026, a Los Angeles jury found Meta and Google liable in a case brought by a young woman who said she became addicted to Instagram and YouTube as a child and later developed severe mental health struggles. The jury awarded $6 million in damages, with 70% assigned to Meta and 30% to Google. That dollar figure is tiny next to the size of those companies. The legal signal isn't. This case pushes the conversation past the usual content moderation debate and into something more uncomfortable for the industry. Whether engagement-driven product design can create liability when it contributes to real-world harm. What the jury actually decided. The verdict wasn't a vague cultural statement about phones or social media. The jury made specific findings. It found that Meta was negligent in designing or operating Instagram. It found that Google was negligent in designing or operating YouTube. It also found that both companies failed to adequately warn users about the dangers tied to those platforms and that their conduct was a substantial factor in the plaintiff's harm. The total award included $3 million in compensatory damages and another $3 million in punitive damages. In plain English, the jury didn't just say harm occurred, it also decided punishment was appropriate. The punitive damages finding is a big reason this verdict will get attention well beyond this one case. Why product design is the real story. What makes this case stand out isn't just that one plaintiff won, it's the legal theory that got the case there. Tech companies have long leaned on Section 230, the federal law that generally protects online platforms from being held liable for content posted by users. That shield is still powerful. But these social media addiction cases are being built around company conduct rather than user content. And that means the spotlight shifts to the product itself, not just to what users posted or whether moderation was perfect. The question becomes whether the platform was designed in ways that pushed young users deeper into unhealthy use patterns while the companies understood, or should have understood, the risks. That distinction keeps showing up in court. On April 10, 2026, the Massachusetts High Court allowed the state attorney general's lawsuit against Meta to move forward, saying the claims were aimed at the company's own conduct, including how Instagram was designed to capitalize on children's vulnerabilities, rather than simply at third-party content. That's why this verdict feels bigger than a single courtroom loss. It fits into a wider effort to treat platform design as a source of legal exposure. The growth tactics under a harsher spotlight. The plaintiff's case pointed to features such as infinite scroll and autoplay, which are familiar to anyone who has used modern platforms. These features were built for a reason. They reduce friction. They keep people engaged. They increase session length. They feed recommendation systems. They support ad revenue. In other words, they weren't accidents. That doesn't automatically make them unlawful. Plenty of design decisions are built to keep people interested. Every publisher, app company, and product team thinks about retention, but this verdict suggests a sharper question is coming into view. At what point does a growth mechanic stop looking like smart product design and start looking like foreseeable harm, especially when young users are involved? That question gets close to the engine under a lot of digital business models, which is exactly why this verdict matters. Endless feeds, autoplay, notifications, streaks, likes, algorithmic nudges, and similar retention loops have often been treated as normal product strategy. This case does not outlaw them, but it does make them easier to examine through a liability lens. That shift alone changes how these features may be judged. Why this could reach far beyond Meta and Google. One verdict doesn't rewrite the internet, but it can change how future cases are argued. This Los Angeles case was a bellwether trial, which means it was meant to test arguments that are part of a much larger wave of litigation. And that wave isn't small. As of April 9th, 2026, more than 3,300 addiction-related lawsuits were pending in California state court against Meta, Google, Snap, and ByteDance. Another 2,400 lawsuits brought by individuals, states, municipalities, and school districts had been centralized in California federal court. That puts the verdict in a much bigger context. This isn't one unusual case built around one unusual plaintiff. It's the first bellwether verdict in a legal campaign trying to push courts to treat certain digital product choices more like corporate conduct and less like protected platform passivity. If that theory keeps surviving, the effect could reach beyond social media. Other online platforms that rely on attention, habit, and recommendation systems may start getting viewed through a similar lens. That doesn't mean every app is suddenly in danger, but it does mean the legal conversation is moving closer to the product team. What founders and product teams should take from this. This isn't an argument against engagement. It's a sign that companies face growing pressure to show their engagement systems aren't reckless, especially when minors are part of the audience. That creates a different kind of product question, and not just, will this keep users active? Also, if this feature is challenged in court later, how would we explain it? That's a very different standard from the one a lot of growth teams have historically used. A feature can lift retention and still create trouble if it looks like it was built to exploit known vulnerabilities, encourage compulsive use, or keep younger users trapped in loops that were never meaningfully guarded. That's why people far beyond social media executives should pay attention. If you build apps, marketing funnels, creator tools, games, learning platforms, or anything else that depends on recurring user attention, this case raises a harder question than the usual ethics debate. What happens when a growth tactic becomes evidence? What this verdict does not mean yet. Still, this isn't the moment to overread one verdict. This ruling doesn't mean Meta and Google have suddenly lost the broader legal fight. Both companies plan to appeal. The damages, while symbolically significant, are still small for businesses of this size. And one jury verdict is not the same thing as a final rule for the whole industry. It also doesn't mean every retention feature is now legally dangerous. Courts will still have to sort through difficult lines involving causation, responsibility, product choice, parental oversight, mental health history, and the scope of Section 230. So this verdict doesn't signal the collapse of the engagement economy. But it's a real sign that juries may be more willing than before to accept the idea that platform design itself can contribute to legally actionable harm. So what is the bigger business message? For a long time, addictive design was treated mostly as a brand issue, a political issue, or a moral argument. This verdict suggests it's becoming something else too, a liability issue. That makes the conversation harder for tech companies to dismiss as politics or PR. When courts start looking at infinite scroll, autoplay, notifications, and similar features not just as UX choices, but as evidence of corporate conduct, the old defense of "we're just a platform" starts looking less comfortable. And that's why this story matters beyond Meta, Google, or even social media. It points to a larger shift in how digital products may be judged. For years, the internet rewarded companies for keeping attention at almost any cost. The next phase may ask a tougher question. What did that attention strategy understand, and what did it choose to ignore? This was based on an article from our blog. You can find the full written article on Tech Help Canada, including sources and visuals. If you found this helpful, you can explore more on our website and subscribe or become a member for updates and perks. If you're watching or listening to this on YouTube, Apple Podcast, or another platform, don't forget to like and subscribe to help us keep bringing you valuable content like this.